So you spend your life building something, right? And you write a will to make sure your wishes are carried out, down to the very last detail. You figure, that's it. It's done. It's the final word, a sealed document that directs your legacy. But what if I told you it's not? What if the law has its own ideas about who gets what, especially when it comes to your own family? And that really gets to the heart of what we're talking about today. What happens when a will forgets someone? It happens way more often than you'd think, through a simple mistake, a sudden marriage, or just because of old, dusty paperwork. And the law's answer is often not at all what people expect. It creates this fascinating and sometimes heartbreaking tug of war between what you wrote down and what the state thinks is best for protecting families.
All right, so here's our game plan. We're going to start with this big picture idea of a family safety net that the law creates. Then we'll dive into the specifics, the really powerful protections for spouses. Then we'll flip it and ask if you can actually disinherit a child. After that, we'll look at what happens when a child is just forgotten by accident. And finally, we're going to get into the modern world of trusts and the massive loopholes they create before we wrap it all up.
Okay, so to really get why a will can be, overruled, you first have to understand this concept of a family safety net. For centuries, laws have been built up to stop spouses and children from being left with absolutely nothing, whether it was on purpose or by accident. It's basically a set of default rules, a backup plan designed to provide a basic level of support.
So here's the key takeaway. Your right to give your property to whomever you want, well, it's not absolute. Think of these laws less like restrictions and more like a series of automatic benefits that just kick in for your family. They're running in the background. And if there's a direct conflict, believe it or not, these protections can be way more powerful than the actual words you wrote in your will. All right, so let's start with surviving spouses because, wow, they have some of the most powerful protections in the entire legal system. And these rights exist completely separate from the will. They don't even go through the whole court process, which means they apply no matter what the will says. I mean, just look at all the layers here. A surviving spouse can often get their deceased spouse's full Social Security check. Then there's a huge federal law called ERISA that basically guarantees survivorship rights to most private pension plans. And on top of that, states give you rights to the family home, a chunk of personal property, and even an allowance to live on while the estate is getting sorted out. These are seriously powerful automatic rights. And to really understand why that pension protection is such a huge deal, just look at this number. By late 2020, Americans had over $33 trillion saved in retirement accounts. It's a massive, massive pool of wealth. And that's exactly why federal law steps in so forcefully to make sure a spouse isn't left out. You literally can't sign away that benefit without your spouse's written, witnessed consent. You gotta love this old cartoon from The New Yorker. It gets a chuckle, but it points to a very serious truth. These benefits are a cornerstone of a family's financial security. But here's the thing. Sometimes the very laws designed to protect people can go sideways and have these totally unintended and, frankly, tragic consequences. Let me show you what I mean with a real case.
Okay, first you need to know this one legal term, the omitted spouse statute. Almost every state has one, and it's designed for a super common problem. You write a will, you get married, and then you die without ever updating that old will. The law just assumes this was a mistake, an oversight, and it automatically gives that new spouse the share they would have gotten if there was no will at all. It's a safety net.
Now, let's look at the Presti case. So in 1994, a guy named W.R. Presti makes a will, leaving everything to a trust for his son. Simple enough. Years go by and his ex-wife, Maria, actually moves in to take care of him as his health gets worse. In 2001, he does something really specific. He changes his trust to give Maria the right to live in his condo for the rest of her life. He clearly wants to provide for her. Weeks later, they get remarried. But, and this is the killer detail, he never updates that old 1994 will before he dies. And here is where it gets absolutely wild. The court in Nevada said that because Maria was a spouse omitted from that pre-marriage will, the will was essentially canceled as far as she was concerned. Now, the law was incredibly rigid. It said the only way to prove this wasn't a mistake was to have it mentioned in the will itself. The court was legally forbidden from even looking at that trust amendment he made for her. I mean, this case perfectly shows the giant canyon that can exist between what someone clearly intended and what a very strict law will actually allow. Okay, so that's spouses. The story is totally different when it comes to children. We just saw how hard it is to leave out a spouse, even by accident,
But what if you want to intentionally cut a child out of your will? The law's take on this might really surprise you. It's a night and day difference. Unlike a spouse, a child has almost zero protection from being intentionally disinherited. In every single U.S. state except Louisiana, you have the absolute right to leave your child nothing. There's no automatic share, no safety net, nothing. If you make it clear, you're cutting them out on purpose. The law is fierce about protecting a spouse, but it generally defends your freedom to give your property to whomever you want, even if that means leaving your own kids out in the cold. And check this out. This might be the most famous and shortest example of how to do it right. This is the entire will of President Calvin Coolidge. Look at that first phrase, "not unmindful of my son John." With just those 6 words, Coolidge made his wishes legally bulletproof. He was telling the court, hey, I didn't forget about my son. I'm aware of him, and I'm choosing to give everything to my wife instead. By doing that, he shut down any possible legal challenge that he'd left his son out by mistake. So what happens when it is a mistake? This is where those pretermitted heir laws we just mentioned come into play. They're built for a very specific situation. You write a will, then you have another kid, and you just never get around to updating the paperwork. The law steps in and says, hey, we presume you would have wanted to include this child, and it tries to fix the oversight. This quote from Jack Gray, man, it just puts a human face on the whole thing. You can just feel the shock and the confusion of being a kid and finding out that because of a series of life events and an old document, you've been left with absolutely nothing from your own father. So here's how it all went down in his case. Gray versus Gray. In 1981, his dad, John Gray, writes a simple will leaving everything to his wife, Mary. At the time, he has 2 other kids. 3 years later, John and Mary have Jack. Then they get divorced, but nobody ever changes that will. So when John dies in 2004, that old will from 81 is all they have. It's a total classic stale will problem. See, you're thinking, okay, Jack is the textbook omitted child, right? He was born after the will was written. Well, nope. The Alabama court said he gets nothing. And why? Because the law had a very specific exception. It said an omitted child is out of luck if the will left pretty much everything to the other parent of the omitted child. And that's exactly what John's will did. It gave everything to Mary. The court decided that the fact they got divorced later was legally irrelevant. It was a super strict, literal reading of the law that ended up doing the exact opposite of what it was designed for. Now, all of these stories we've talked about, they all have one thing in common. They're about wills. But here's the thing. Today, more and more wealth is being passed down, not through a will, but through something called a revocable trust. And this huge shift is creating a massive legal loophole that these old family protection laws, they were just never built to handle. Okay, so what's the big deal? Well, here's the fundamental difference you have to get. A will goes through a public court process called probate. That's the arena where all these laws about forgotten spouses and children come into play. A revocable trust, on the other hand, is a non-probate asset. It's like a private contract. It completely bypasses the probate court. So the huge question becomes, do these family safety net laws even apply to trusts at all? The Oklahoma Supreme Court tackled this exact issue in a case called the Estate of Jackson, and their ruling was crystal clear. They looked at the law for omitted children, and it used the word will. It did not say trust. And so the court concluded that the law only applies to wills. A child left out of a trust has no legal claim under that statute. The court basically threw up its hands and said, look, if the legislature wants this to apply to trusts, they're the ones who have to rewrite the law. And if you want to see how unbelievably messy this can get, just look at the chaos around Anna Nicole Smith's estate. Her will specifically named her son Daniel, but it poured her estate into a trust that used the plural word children. It also had a clause trying to disinherit any future kids. So when her daughter Danny Lynn was born after the will was signed, it created this massive legal puzzle that was all about trying to figure out what these conflicting documents actually meant. So, after all of this, what's the big takeaway? After looking at all these cases, from Coolidge to Gray to Jackson, one thing becomes incredibly clear. The law tries to create a safety net, but that net is full of holes, bizarre exceptions, and just plain outdated ideas. Relying on these default laws to fix things is a total gamble. At the end of the day, the only real, final word is your own, and it has to be expressed through a clear, updated, and complete estate plan. And that leaves us with this huge question we need to think about for the future. For 100 years, our laws were all built around the will. But we don't live in that world anymore. We live in the age of the trust.
So does it really make any sense that a child forgotten in a will gets legal protection, but a child forgotten in a trust might get absolutely nothing? As the tools we use to pass on wealth change, it forces us to ask, shouldn't the legal safety net that's supposed to protect our families change right along with them?